New Mexico Broker Basics, page 25. B. The buyer slash tenant's motivation for buying slash leasing. Or C. Any other information the buyer has requested in writing remain confidential unless disclosure is required by law. 9. In the event the broker is working for the landlord owner as a residential property manager, the broker additionally owes to the landlord owner all duties owed under the law of agency. C. In addition to the broker duties owed to prospective buyers, sellers, landlords, owners, and tenants as set forth in this section 16.61.19.8a. Brokers working as property managers for a landlord owner owe the following duties to tenants. 1. Prompt accounting for all money or property received by the broker from the tenant, including issuance of a receipt for cash received. 2. If a residential property manager, written disclosure that the broker is the agent of the owner of the property and not for the tenant. In the commercial property management context, written disclosure of the broker's relationship with the landlord owner. D. Broker obligations to other brokers. Brokers owe the following professional obligations to other brokers. However, brokers are not required to provide to one another a list of these broker obligations. 1. Honesty, reasonable care, and ethical and professional conduct. 2. Timely presentation to offers or counter-offers and responses thereto, unless otherwise agreed to in writing by the party to whom the broker is directly providing real estate services. 3. Active participation in assisting the party to whom the broker is directly providing real estate services in complying with the terms and conditions of the contract and with the closing of the transaction, unless otherwise agreed to in writing by the party to whom the broker is directly providing real estate services. 4. Compliance with local, state, and federal fair housing and anti-discrimination laws, the New Mexico Real Estate License Law and the Real Estate Commission rules, the New Mexico Uniform Owner Resident Relations Act, and other applicable local, state, and federal laws and regulations. 5. Written disclosure of any adverse material facts actually known by the broker about the property or the transaction, or about the financial ability of the parties to the transaction to complete the transaction. Adverse material facts requiring disclosure do not include any information covered by federal fair housing laws or the New Mexico Human Rights Act. 6. Written disclosure of any potential conflict of interest that the broker has in the transaction, including but not limited to any material interest the broker has in the transaction, or any relationship of a business, personal, or family nature that the broker has with a party to the transaction. 7. Non-interference with a purchase agreement or any express written agreement that another broker has with the buyer, seller, landlord, owner, or tenant. Brokerage relationships. Brokerages working with consumers, either as customers or clients, may do so through a variety of brokerage relationships. These relationships include, but are not limited to, a transaction broker relationship, an exclusive agency relationship, a dual agency relationship. For all regulated real estate transactions, a customer or client may enter into an express written Page 26. Agreement to become a client of a brokerage without creating an agency relationship, and no agency duties will be imposed. Transaction broker relationship. The Licensing Act and Commission rules and regulations create a non-fiduciary relationship called transaction broker between sellers and buyers as the default relationship. In this type of capacity, the licensee does not represent either the seller or the buyer as an agent. In this type of relationship, the broker may enter into an express written agreement with the party, thus making the party the broker's client, but with no agency duties imposed. All parties must sign the written agreement. Brokers may enter into listings agreements with owners or buyers in a transaction broker capacity. The broker is not acting as the agent of the person, but simply as a broker. Exclusive agency relationships. Exclusive agency relationships in New Mexico can only be created by an express written agreement between a person and a brokerage, wherein the brokerage agrees to exclusively represent an agent. The interests of the person in a real estate transaction. Such agreements include buyer agency, seller agency, designated agency, and sub-agency. Other forms of exclusive single agency. Designated agency is a form of exclusive agency and allows for a qualifying broker to designate an associate as agent for the seller and another associate as an agent of the buyer. In a single in-house transaction, designated agency must be in writing and be made a part of the listing and buyer employment agreements. In designated agency, the broker is expected to remain an impartial party between the seller and buyer. A sub-agent is the person delegated by the agent of a principal to also act on behalf of the same principal. The appointed person becomes an agent of the principal's agent and a sub-agent of the principal. Licensees associated with the qualifying broker are agents of the broker. The broker is the principal. Dual agency relationship. Dual agency is the act of on the part of the licensee of representing both buyer and seller in a real estate transaction in an agency capacity. The real estate license law permits dual agency only upon written disclosure to all parties to the transaction. All parties must sign a dual agency agreement in addition to the listing and buyer employment agreements. See Realtor Association, New Mexico, RANM, Form 1301. Although the license law permits dual agency by obtaining written consent and signatures of all parties to the transaction, licensees must be aware of the responsibility they incur when representing both parties to the transaction. Fiduciary agency relationships. A fiduciary relationship is a relationship that implies a position of trust or confidence. The term fiduciary describes the faithful relationship owed by an agent to a principal. The fiduciary relationship imposes certain duties, obligations, and high standards of good faith and loyalty on the agent as fiduciary of the principal. Page 27. The fiduciary duties automatically arise with the creation of any type of agency. They are based on the concept that an agent must hold the interest of the principal above all other interests in a transaction, including the interests of the agent. Among the duties a fiduciary owes the principal are the following: obedience, loyalty, disclosure, confidentiality, account for all monies and property, reasonable skill, care, and diligence. Note that the duty of confidentiality continues beyond termination of agency. An agent is generally subject to the following two distinct areas of liability for the breach of fiduciary duties. The principal can sue in a civil court. The principal can file a complaint with the Real Estate Commission. Client/principal. Client/principal refers to the consumer who employs an agent to act on the consumer's behalf in the sale or purchase of property. The client is normally the agent's principal, and the agent works for the principal. The principal is the only person to whom the agent owes fiduciary duties. According to the Commission rules and regulations, the word client is used when a broker has entered into a written agreement with a party. Third party. Customers are third parties with whom the broker has no agency agreement or relationship. The licensee does not owe fiduciary duties to third parties. However, the licensee is expected to treat the customers with honesty, disclosure, and fair dealing. Respondent superior. Respondent superior is an agency law concept meaning let the master answer. This legal maxim means that the employer is liable in certain cases for the wrongful acts of the employee and a principal for those of the agent. In the real estate business, This means that clients may be liable for the wrongful acts of their broker. In a recent New Mexico Court of Appeals case, the court made clear that the associate broker in an agent of the qualifying broker for tort purposes. Robertson versus Carmel Builders, opinion, pound 2004, NMCA 056. Listing agreements. A listing agreement is the contract between the brokerage and the seller of real property, authorizing the brokerage to market the property. It will include a term of the agreement and an agreement for the seller to pay the brokerage a fee or a commission.